Agencies statewide have or are in the process of drafting formal MOUs, Memorandums of Understanding, MOAs, Memorandums of Agreement, and IGAs, Intergovernmental Agreements, so clearer lines are drawn and understood by all agency personnel.
I think the cross-commissioning is absolutely crucial, whether it's tribal law enforcement receiving their special law enforcement certifications through the BIA, or whether it is county or state law enforcement agencies receiving cross-deputization or cross-commissioning from the tribe in order to assist with tribal investigations on the reservation. I think that those memorandums of understanding and agreements between those agencies is absolutely crucial to combating the issues that really face their common communities in which they live.
I know DPS, from an agency standpoint, we would like to have agreements with each tribe we work in and around. We want to help out the agencies whenever they need it. We want them to be able to help us when we need it. At the line level, I know that occurs, but we don't want our troopers or their officers to be worrying about any legal issues, and so that's where these agreements, if they're made agency to agency, really make it a lot easier for the line level guys. And then all they need to worry about is their officer safety or the public safety, not worry about if they're going to be violating a tribal or state law by either taking somebody off the reservation when there wasn't an extradition policy or whatever it may be. These agreements outline those things, and the training component for each tribe, I think, is very important.
It's a meeting where we have to get together and talk out what kind of services and how we're going to scratch each other's back when something happens. And those agreements really come into play, because it's just like, if we didn't have those agreements, we couldn't take some of their call like trucks, and we have a lot of domestics down there, and they don't have too many officers to cover, so we have to send our officers down there and cover for them. We, being the Department of Public Safety and me personally, have been in verbal agreements with, as far as the chiefs on down. I mean, the Hopi chief and I went to the academy together, so we've known each other a long time. If he tells me he's going to do something, I totally believe him and understand it, and I guarantee it'll happen. That being said, let's say an officer-involved shooting occurs while we're backing them up. When it gets to the court aspect of that, the verbal, unfortunately, today doesn't seem to mean as much.
We have the meetings, we tell them what we want to do. The teams, the outside agencies are all aboard, and then a new council comes in. And that new council says, no, we're not doing that. So, I mean, their terms are 4 years, depending on the tribe. It could be 2 years, it could be 4 years. But, that could happen. You could be okay one day, and the next day it could go away.
Typically, jurisdictions that share boundaries will have some sort of MOUs or memorandums of understanding to determine their shared interests and what their cross-jurisdictional boundaries are, and their mutual assist agreements and that sort of thing.
And I can say with our current administration, they have made agreements with the tribes a priority. And we're pushing forward with that, and we know it's not going to happen overnight. Just with any government, it doesn't happen overnight. But if 5 years from now, if we can say we have agreements with 90% of the tribes, I would love to come back here before you and say, you know what, 5 years ago we had 20%, now we're at 90. That would be a win.
In our case, we look at mutual aid agreements more than anything because we're all post-certified. We're all post-certified, and it's asking for that assistance when it's needed. Even with the highway patrol, if you want to have a Hualapai commission, we have to have a mutual aid agreement.
I understand where a lot of the tribes may be hesitant. They don't want to lose any sovereignty. But at the street level, we're just all trying to work together well and trying to create an environment where we can easily do that. We want to help the tribal PD, and they want to help us, and I think that's the bottom line, because it gives a better service to the community. And I think most of the tribal chiefs are in support of it because they know over the years we've been a great team. We've worked well together, and we all want that to continue. The state doesn't want to take anything away from these tribes. We just want to be able to help the community and help the officers, and we want them to be able to help us. These agreements are a win-win.
Cross-deputizations is essentially another name for commissions, in which a non-tribal police officer applies for tribal authority to enforce tribal laws on that reservation.
I think one good example of that is the Department of Public Safety. Oftentimes when they're, especially when their roads go through the reservations, they will obtain cross-deputization so that they can assist, particularly with fatality, accidents, vehicular manslaughters, DUI, investigations, and that sort of thing.
You have a tribal fair that occurs. That agency calls DPS or whatever agency might be to come in for assistance. If they're all cross-commissioned, it's very easy. We can bring in 10, 15 people to help with that fair for that weekend, and it just multiplies the local force right away by having that cross-commission.
Many times there is a training session involved. With the Navajo Nation, it's a 2-day training session, and then the officer actually goes before a tribal court judge and is sworn in. He receives the commission, he or she receives a commission card with their photo on it, and they have authority to enforce tribal laws on the Navajo Nation.
The cards will come from BIA, so if they are cross-deputized, but it has to be an agreement between the agency, the tribe, and BIA, and the council has to approve it.
Cross-deputization or cross-commissioning helps only with enforcing tribal law on tribal members. Gives them the jurisdiction to do that when we're not available.
Cross-deputization can be good and can be bad. For the tribe, if we cross-deputize, like I said, it'll be an assist. It won't be no more than that for a tribe because they want to keep their sovereignty, and we don't want other municipalities coming on just because they find out there's a drug bust, there's drugs going through the tribe, and we want to be a part of that.
With our Safe Trails Task Force and our Safe Streets Task Force in Northern Arizona, we have police officers, state and local police officers that we designate as task force officers. We get them cross-deputized so that they also have federal powers to investigate on the reservation.
Different tribes have different procedures. Some of those tribes will not issue commissions, but they do have a mutual aid agreement that basically it grants the same thing. There's just no card behind it. So it varies from tribe to tribe, and some tribes choose to exercise their sovereignty by doing their own enforcement, and they don't grant commissions. They don't do the intergovernmental agreements. They have the resources to be able to handle the issues on the reservation by themselves, and that's an exercise of their sovereign powers.
It's really nice in this day and age where resources are so limited to be able to know that when you call for backup, that you're not just calling your agency, but anyone else who's got the ability to go to help. And I know if I was an officer out in the middle of nowhere and I was in a bad situation and calling for backup, it doesn't matter to me who shows up. It's sure nice to have somebody be there to back you up.
It can become very confusing from a legal aspect because you have to be in the scope. You have to be within the scope of your cross-deputization agreement. You have to be operating under the authority of that agency which has, deputized you.
The problem without the written agreement, without the cross-commission, when our troopers or any agency goes in to assist a tribal PD, basically they would have to be teamed up with the tribal members. So it would be more of a backup type scenario. But technically that state officer without cross-commission would have no authority on that reservation. So the authority would come from the partner there. And it puts that state certified non-tribal cross-commission person in just a very difficult position and a very uncomfortable one having been there. It's not a very comfortable scenario to be in.
Hot pursuits are relevant to criminal jurisdiction in Indian country because that could be sort of the exception, if you will, to the jurisdictional boundaries. There is case law that supports that if somebody is in hot pursuit, whether it's off the reservation or on the reservation, if somebody is in continuing hot pursuit of an individual fleeing from one jurisdiction to another, that law enforcement agency would have the jurisdiction and authority to go into the neighboring jurisdiction under which they normally wouldn't have jurisdiction, as long as they are in hot pursuit.
What our troopers are trained to do is, one, they'll take disposition and secure the person, and then contact the local agency. The local tribal agency will respond and take disposition if our troopers are not tribal cross-commissioned. If it's a scenario where we're cross-commissioned, we take disposition of the case, we pull our own report number, we book the person into the tribal jail, we tow the vehicle, and we take complete disposition of it. If it's a situation where there's no agreement between the tribes and there's no cross-commission, we secure the person, contact the tribal agency. That tribal agency responds, they take disposition of the person, they take the report, they deal with the disposition of the vehicle and booking the subject. The trooper's responsibility at that point is to write a report, document what they had, relay that report to be a supplement for the tribal officer's offense report.
Crimes don't sort of stop at tribal boundaries, and so we have a lot of these cases where a crime may occur in one jurisdiction, but the individual may flee into another jurisdiction. So we have a lot of instances in which we have hot pursuits that occur either from tribal land onto state land or from state or local jurisdiction into tribal land. And the general rule of thumb is that if you have a local or state officer who is pursuing a suspect that has committed an offense within their jurisdiction outside of the tribal boundaries, that they can continue to pursue that person onto tribal land, and assuming they never lose contact with them or sight of them, if they can arrest them and on those charges that were committed outside tribal land.
Take for instance, if the Kingman or Mojave County Sheriff Department had a pursuit, it was a tribal member, and they come onto the reservation. It doesn't mean that they have to stop at the reservation and they'll notify us, but they can continue their pursuit onto the reservation. If it stopped within the boundaries of the reservation, and if they're Indians, we have jurisdiction over them. So that means we can make the arrest and then take them to our tribal jail, and they can issue a warrant, and then we can file a fugitive injustice warrant, which means that we can arrest that guy and transport him or give him back to the state, and they can prosecute him with whatever charges they need to out there.
Non-tribal officer, for example, can make a traffic stop on Indian country because until you actually make the stop, you don't know the background of the person that you're stopping, the ethnicity. So once a traffic stop is made, and if it is on Indian country by an officer who doesn't have a commission or there is no intergovernmental agreement between the agency of that officer and the tribe, then the officer has to either allow the person to leave or to detain them and turn them over to a tribal police officer.
If it is a non-Native American individual, our troopers can take disposition of that case and charge them with state law. If they're cross-commissioned, it doesn't affect that at all. So if it's a tribal member, we can take full disposition of it through tribal statutes. If it's a non-tribal member, then our trooper can take disposition of it through state statutes. The biggest difference there is which statutes are you using, the tribal certified or the state, and what facility are you booking? Are you going to be booking at a tribal facility or are you going to be booking at a state facility?
Somebody committed a crime in the city of Kingman. They were coming back through the reservation, and let's say that they're pursuing this individual, never lost contact with him, call us, tell us that he's coming, and let's say we spike him and we stop him on the reservation. And let's say it turns out to be a Navajo, okay, who committed this crime. That city of Kingman officer who's chasing the individual can charge that individual in the state and go through the FFJ process just as well, but we'll arrest him for a violation of that crime. And again, if it's a non-tribal member or non-Indian, we'll allow them to take that individual off without a fugitive from justice. What changes it is the status of that individual. Are they Indian or non-Indian?
The dynamic changes if you have a hot pursuit and, for instance, the officer loses track of them for 30 minutes and then sees a vehicle that matches that description. The question then is, can they then make an arrest? And my response would be no. At that point, once you've kind of lost contact with them for a significant period of time, then you're probably going to have to seek to get them through the extradition process. When
a pursuit is initiated on the tribal land, goes on to state land. Because the pursuit occurred on state land, our troopers can book them into a state facility at that point. In some cases, you can have almost double jeopardy where the person could be charged by the tribe for tribal violations as well as the state charges. That's not something that we pursue, but I've heard of situations that's occurred where it was a really long pursuit. Their actions were so dangerous and egregious that charges were filed on both.
If a tribal officer is involved in a pursuit, for example, beginning on Indian country, and that pursuit goes into a municipality or out into the county off the reservation, then that officer, as long as they're post-certified, can continue the pursuit and make the traffic stop, make the arrest, And whether that person is tribal or non-tribal, that officer has the opportunity to decide, will I take them back and charge them tribally because the pursuit initiated on Indian country, or do I just book them into a county facility and charge them under state statutes?
You know, there's sort of what the law allows, and then there's also, from a practical perspective, what we should do. And I think communication is always very important. I think that I can't envision that, for instance, if you lived in the metropolitan area, if you were a Tempe police officer who was pursuing someone into Phoenix, that you wouldn't give a courtesy notification to Phoenix that you were in pursuit of someone. And I think the same is true whether you're dealing with Indian country. You know, if you're an officer and you're pursuing someone onto the reservation that's committed an offense, my best advice would be reach out to them, let them know you're coming, have them assist you.
We also have our own laws and our own guidelines that we have to follow in tribal PD. So if our guidelines for the police department say, you know, you shall do this. If you go off the reservation and there is a fresh pursuit, you will do this, you shall do this. So we have our guidelines that we have to follow. And, you know, every tribe is different, every police department is different.
Investigations are going to be something a little more of a long term. It's going to be a complete analysis of a case. It's going to include interviews, interrogations, crime scene, basically everything to do with a particular case.
And investigations in Indian country are just like investigations anywhere else. You know, being all state certified peace officers, we're all taught basic investigation skills. You know, with the tribal law enforcement agencies that have criminal investigators that have gone through the CITP course through FLETC. You know, of course, they take that one step further, but it's just the process by which you investigate the crime that's occurred to determine whether or not there's the eyewitness testimony or the physical evidence or any sort of evidence to show that that person that's accused of committing the crime has actually committed it. And it's the same in Indian country as it is outside of Indian country. You still have to show probable cause. You still have to show that you have the evidence to support what the charge is.
When you're an investigator working in Indian country, there aren't any specialized units. You know, in the city limits, you have, you know, either homicide unit, you have your family crimes unit, you have your sex crimes unit, and they respond in accordance to the crime. Well, in Indian country, it doesn't work that way. You learn the whole scheme of crimes. You go out, sometimes you're on your own. Resources are very, very limited.
The criminal investigator for the PD has its own rank. So I'm actually in charge of all the major criminal investigations that happen on the tribe. It's an administrative supervisor position, and I supervise 2 other detectives, and we you know, do all the major casework. So anything from child abuse, sexual assaults, homicide, armed robberies, just about everything we have had come through the doors.
There are different protocols and different memorandums of understanding between different agencies that patrol and have jurisdiction in different agencies. So it may be that in some places, so tribal crimes are going to be investigated solely by tribal law enforcement, but you'll have federal crimes where, depending on the existence of Bureau of Indian Affairs or FBI in those particular jurisdictions, there may be specific memorandums or agreements between those agencies as to who will investigate which crimes. And there's typically a protocol for each reservation so that they know who to call when certain offenses take place.
Investigators like the patrol, they have to know the laws, and where we know more about federal laws, statutes, as opposed to the state. We deal with the U.S. attorneys as opposed to the DCAs or the prosecutors in the state. We go to a different court building. They're housed separately.
Some, like Salt River, are very sophisticated and can do full investigations of any kind of crime that occurs within their community. They've got arrangements with Scottsdale Police Lab and other entities to do the lab work, and so they can pretty much do everything. Others could be very small agencies and not have the ability to do much beyond the more low-level type crimes, and they might need assistance in that regard.
I worked a lot of sex crimes and child crimes, so that would also encompass taking the child for the forensic interview, going to the SANE clinic, taking the victim of a sexual assault to the SANE off the reservation, because there's not a lot of tribes that have clinics on the reservation. Same with the forensic interviewing. We'd have to go off the reservation to do that. And you learn from the beginning to the end, literally. And sometimes you're out there for hours and hours in a day, just trying to take care of your scene.
I think they're more strict with ensuring that you have probable cause to arrest that tribal member and put them in tribal jail than they are off tribal lands, where it's, more likely than not this person did it, whereas in Indian country it's, yeah, they did it.
Investigators in Indian country under the BIA compact, they have to go to a federal academy. And basically the federal academy, I went to Glencoe, Georgia. And it's a 3-month academy, and you just learn federal law. And then you graduate, and you're under the umbrella of Bureau of Indian Affairs. I'm not listed as Gila River or Salt River Agency. I'm under Bureau of Indian Affairs. And you graduate, and then you have that investigation certificate.
I think the only major difference is when you interview somebody during an investigation, whether it's a witness or a suspect. In Indian country, you kind of take into account that cultural and historical backgrounds, as well as their heritage. You may not go in right away and say, hey, did you do this? You still build that rapport with them, just like you would non-Indian country law enforcement. But having in the back of your mind the thought process of, because they're a tribal member, their culture and heritage, they may understand something differently. So you have to be sensitive to that.
An investigator in Indian country learns a whole lot in a short amount of time. And basically, you learn how to do evidence, write reports, do grand jury. I mean, you're doing it all yourself. And the manpower is just something that will always be with Indian country. And because of the large geography, and just the resources are just not available for Indian country.
What an order of protection is that's something that's generally filed by the court. Basically what it's supposed to do is protect the filing individual, kind of like a restraining order.
One of the things that I think all officers need to understand is the full faith and credit in orders of protection, and that applies to tribal orders of protection as well. So we would give them the same authority, the same validity, same power that we would an order of protection that was issued in the state of Michigan, for example. It's a matter of verifying that the order of protection was issued, that it is factual, getting the details on that, confirming with the court, but it has the same force and effect as an Arizona order of protection, a state order of protection would.
The nice thing about orders of protection is with the Violence Against Women's Act, Reauthorization Act of 2013, is that Congress also enacted 3 new areas under VAWA. One is the interstate violation of a protective order, a protection order. The nice thing about that is in the past, interstate always meant you had to cross state boundaries in order for that to occur. In the Violence Against Women's Reauthorization Act, for the first time, Congress recognized tribal boundaries the same as state boundaries. It said if a person crosses a tribal boundary, then that's interstate, moving in interstate commerce to violate a protective order.
If someone who has an order of protection against another individual comes onto tribal lands, and they're both there and a violation of that order of protection occurs on tribal lands, those tribal officers still have to take enforcement action on that. It's the same way with orders of protection issued out of tribal court. If both individuals mentioned in that order of protection, the protected party and the person who the order of protection is against, are off tribal lands and a violation occurs, it's important for officers to know that under the Full Faith and Credit Act, that is still an enforceable order of protection. And it's not their job to determine whether that order of protection is valid or not. The only thing that most of Indian country doesn't do right now is enter those order of protections into the National Crime Information System. They don't do it because most of the tribes don't have access for that.
Let's say that an individual's in Flagstaff and intends to travel to Tuba City on the Navajo reservation to violate a protective order. They're within the state, they haven't crossed state boundaries, but they crossed that tribal boundary, and that qualifies. And likewise, let's say you're on the Navajo reservation, you never leave it, but you cross from Arizona into New Mexico, still on the reservation, to violate a protective order. That qualifies too.
Tribal order protections, state orders of protection, wherever those orders of protection are obtained, they should be given full faith and credit in the other jurisdictions. So if somebody has a tribal order of protection, it's good in the state system and vice versa.
This concludes Unit 9 of this training. Upon completing the Unit 9 assessment module, we will take a look at how good working relationships can lead to a positive outcome. Now you will be automatically redirected to the Unit 9 assessment module.